A landlord in Oakland asked a prospective tenant one simple question during a showing. "What country are you from?" It felt like small talk. It cost him a 5-figure fair housing settlement. If you're a landlord in California, especially in the Bay Area, you need to watch this. Most landlords know the basics: race, religion, disability. But California's Fair Employment and Housing Act goes much further. We're talking 20+ protected classes, and cities like Oakland and Berkeley add even more on top of that. Complying with federal law isn't enough here. You can follow federal rules perfectly and still violate California law. Let me walk you through the 4 areas where we see landlords get into trouble most often. Number 1. Source of income. Since 2020, you cannot refuse to accept Section 8 vouchers, SSDI, SSI, or other government assistance in California. You can require income of 3 times the rent, but you have to count voucher income the same as a paycheck. Number 2. Familial status. Saying things like, "This is a quiet building," or "It's great for young professionals," even casually, can be used as evidence of discrimination against families with children. Number 3. Disability and ESAs. Emotional support animals are not pets. You cannot say no just because you have a no-pet policy. And you cannot ask about someone's diagnosis, only whether an accommodation is necessary. Number 4. Immigration and citizenship status. Even casual questions like, "Where are you originally from?" during a showing can create legal exposure if that applicant is later denied. Here's the part that surprises most landlords. Intent doesn't matter. You don't have to mean to discriminate. If your process is inconsistent, or if you asked a question you shouldn't have, that's enough. Going with your gut? Not a legal defense. They just seemed more reliable. That explanation won't hold up if the other applicant files a complaint. The good news is, there's a straightforward way to protect yourself. Write down your screening criteria before you accept any applications. Minimum income, credit score, rental history. Apply those criteria to every applicant in the same order. Approve the first applicant who fully meets your written criteria. Document everything. And describe the property, not the person. Say second floor walk-up. Don't say perfect for a single professional. Bay Area fair housing enforcement is active. Advocacy groups test landlords regularly, calling to ask if you accept Section 8 or whether a unit works for someone with a wheelchair. One wrong answer to the wrong caller can trigger a formal investigation. We've linked the full article in the description. It includes a compliance checklist you can screenshot and use today. And if you'd like help managing your rental property the right way, we'd love to talk. I'm Emery with All East Bay Properties. Thanks for watching.